Hello, landlords. This is your host, Matthew Lyman of the Landlord Advocates, where we help landlords become better landlords. Yesterday, our team was producing a video to help you learn some more stuff about these laws of New York State, of recently passed laws that affect the filing of evictions, when they're going to be heard, what's going to happen in court. We were in production of that when we learned from our resources and contacts that the laws had changed again. So we had to scrap that video and start anew. And that's what this video is today, July 9th. As most of you know, this channel has been advocating on the channel and other social platforms, media platforms, and in real person life, changes to the law that forbid landlords from filing evictions after or prior to August 20th, if the tenant was on unemployment, eligible for unemployment, or facing a financial hardship. We have been pushing, allow the landlords to file so that if the case is heard after August 20th, it would be very close to that day. Our arguments were listened to, as well as other advocates of landlords and landlords themselves. They were listened to, and the court said, yes, we will allow you to file those evictions. Landlords all over New York State were jubilant, thrilled, happy, excited, joyful, but this channel knew, not so fast. Not so fast. We knew that somewhere up the sleeves of whoever, the judicial, the executive, or the legislative branch, there was going to be rules, regulations, and acts, impediments to landlords doing exactly what it was that they said that they could do. We knew that, and we were right. And the video yesterday was to explain all of that which we knew was going to be impediments. But like I said, during production, we had learned that the laws had changed. And that's what we're here to talk to you about. We have some great news, and we have some bad news. And here's that information now. As you know, now you can file evictions in court to have your tenants evicted. That's the great news. The other great news is that the governor's executive order 202-28, which said that you cannot file evictions until after August 20th for those tenants who are on unemployment, eligible for unemployment, or facing a financial hardship. You cannot file those evictions until after August 20th. That executive order in relationship to residential tenants is dead. It does not exist any longer. You can file evictions now, regardless of unemployment, eligible for unemployment, or financial hardship. You can file them right now in the courts. That's the great news. This is super. We can do it. That's great. That's what we've been asking for. But wait a minute. You're now, from here on out, is the bad news. The bad news that you have to now be faced with and have to deal with, landlords. The filing of these evictions cannot be done in person. They can be done through the mail. All of them have to be done through the mail. You have to send the original to the court along with a copy. The court will take that when they take it and put a court date on it, put a docket number on it, and mail it back to you. When that will be, we don't know. It could be a week after you send it in. It could be 4 weeks after you send it in. Now, not all courts are allowing filings at all. So you need to call up your local court. Towns and villages, we're not even sure. We don't think that they are even allowed to do it yet. But in city courts, you need to call up your city and ask them. Because we know that some are saying, no, we're not accepting filings at all. And the reason behind that is that the cases that were filed prior to March 16th are going to be heard first. They're going to be heard before ones that are filed after March 16th. Rightfully so. Those people have been waiting for months to have their case heard before you were. And you say, okay, great, the case is going to be heard, they'll get them out, then we'll be able to get in and get this ball rolling and get the train going. No, that's not the case. That's not the case. These cases that have already been filed had to be heard in what's called a virtual settlement conference. And what that is that the landlord must hire a lawyer. The tenant must have a lawyer. Those two will discuss the case between each other and come to a settlement. They then contact the court. The judge will be a part of that virtual settlement conference. He or she will hear the settlement and offer it into the record as it's been settled. The judge cannot render a decision in this case. He or she is just here to listen to what the settlement is and offer it into the record. If there is no settlement and there is no get-together, then these cases are going to be put out for a hearing in front of a judge. When that will be, who knows? Who knows? Now also, what benefit does the tenant have in those cases prior to bringing a lawyer on board, to having a virtual settlement conference, when the possibility may happen, doubtful, but it could happen, that the landlord will get exactly what they want. They will get the warrant of eviction. They will get the judgment for background and get the tenant out. What is the benefit to the tenant to engage in this virtual settlement conference? Our team believes that those conferences are worthless. Harsh as it may sound, harsh as it may seem, we do not believe that they're going to gain any traction. I don't see that happening. We don't see that happening. Now, cases that are after that date, that you file through the mail, they give you a court date. That sounds great. Great. We have a court date set for September 9. We're in court set September 9. Super. Not so fast again. You're not in court on September 9th. Unless the court opens up, you're not. Now, you're put in that position of a virtual settlement conference where you have to have a lawyer, the tenant has to have a lawyer. So the same scenario raises its head for evictions prior to March 16th and after March 16th that are filed. So the scenario is the same. But the difference now, in the cases that are filed now, there's additional work that the landlord must do when they had the tenant serve those eviction papers. There's a document that they must attach to the non-payment eviction papers, but also must be attached to the holdover eviction papers as well. That document is this. What this document says is that the tenant can have days or weeks to file an answer to these court papers that you just had served upon them. They have days or weeks to file an answer. Now, we know a very simple way that a tenant can file an answer, but we are not going to help them perfect that answer. There's no way we are going to do that on this channel, anywhere, on any social media, on anything. We are not going to do that. Let them get a lawyer to do that. Our team and our lawyers on our team are not going to do that. You have to give this document to the tenants. I'm keeping this up here so that if you're going to have a copy, you can make a copy of this, you can type one out yourself, but it must be given to the tenants. Every tenant in a holdover and non-payment must receive this document that you are looking at right now that I'm showing you. You must give them that. Now at the bottom you see a website. The website on this one is for evictions outside of New York City. But you take this and you eliminate outside and the dash, and just put the /NYC/. That is just for New York City. Now, when you go to that website, there's information on there that will make landlords very, very angry. I know they make me angry. This is what they will see. They will see this, and they will see another page that we didn't print out because it's just malarkey. On this page, the part that is so aggravating to this channel and will be aggravating to you, the landlord, is this. The information below is designed to help you find a lawyer, or if you do not have a lawyer, to help you learn about your legal rights and the resources that the court system provides to help you with your case. Are you kidding me? Are you kidding me? The landlords have to provide this information to the tenants so that they can find resources and get legal assistance in order to counter your argument that you want them gone. That you want them gone for non-payment of rent. You want them gone because you want them gone in a whole. You just want them gone. You have to provide that to every one of them. Every single one of them must be provided that. How fair is that? How fair is that landlords must provide that? Tell me that. How fair? You should not have to provide this information to the tenant. That's like handing a gun to your enemy and saying, oh, wait a minute, sorry. I don't think I put bullets in the gun. Let me check. Oh, here you go. Now you got bullets in your gun. Thank you very much. It's not right. But that has to be provided, and that has to be provided in holdover evictions as well. Now, as you know, in a holdover eviction, it has nothing to do with rent. Now, we know that a lot of you landlords know that with this executive order, getting a tenant out for non-payment of rent was going to be a monumental task that probably was never going to happen during this COVID-19 crisis. Not going to happen. So you decided to do here in New York a 30-day, based upon lease violations, or based upon length of tenancy, or length of lease, a 30, 60, or 90-day. Then that way there you can get them into court. There's no issue with back rent. We just want them gone. They haven't paid the rent. Go. I'm sorry. It has nothing to do with rent. We want them to know. Even though in the back of our mind we know they haven't paid rent, we can't present that argument in court. We just want them to leave. Well, now with that document that I just showed you, the tenants in a holdover case can present the argument of a financial hardship or collected unemployment or eligible for unemployment. Now, the law of the land is no longer the Executive Order 202-28. It is the Tenant Safe Harbor Act of 2020 that Governor Cuomo signed into law on June 30th, 2020. Now, we're not going to go into the depths and discussion of that Tenant Safe Harbor Act. That is on our video produced on June 9th, 2020. That goes into elaborate discussion, detailed discussion on the Tenant Safe Harbor Act. Now, at the end of this video, there will be that video in the upper corner that you can click on and you can play that. Now, until we get 1,000 subscribers, hint, hint, subscribe please. Until we get 1,000 subscribers, we are not allowed by YouTube regulation to put down in the description box an actual link to that video. So you'll wait to the end of the video and you'll be able to see a full description of the Tenant Safe Harbor Act of 2020 that Cuomo signed into law on June 30th, 2020. So now your case has been filed. You're not going to have a hearing. The virtual settlement conference is not going to happen because it's just not going to be what you really want. So now you're in front of the judge. When that will be, who knows? September, October, who knows when that will be. But you're in front of the judge, and you're arguing your case that the tenant needs to be evicted for non-payment of rent or as a holder. I need them gone. I want a judgment for what they owe me, and I want the immediate eviction. Now, in the holdover case, as you know, money was never an issue. But landlords who are doing holdover evictions usually bring up to the court, Your Honor, if the issue of them facing a financial hardship or having unemployment or any one of those variables under the Tenant Safe Harbor Act, and that's being introduced as a defense for them not being evicted, then we want to introduce the back rent that they owe in this holdover. It is not fair that they can bring up the defense of money, but yet the landlord cannot bring up the fact that they owe rent money. It shouldn't be one way or the other. It should be both. If the issue of rent not being paid because of COVID-19, or a defense and a holdover that rent was not paid, the holdover that you shouldn't be evicted because you faced a financial hardship, the landlord should be able to get a judgment against you for the rent. Now, in the non-payment case, you're in front of the judge now. They bring up the defense of a hardship, unemployment, SSI, SSD, HEAP, food stamps, actual rent payments from social services. They bring up whatever argument they may have in order to claim financial hardship. Now, the court has an option then. And members of our team, we had a disagreement. Some members of the team believe that the court will rule on the side of caution and say that the tenant did face a financial hardship. whatever that is. We still don't know the pure definition of a financial hardship. Other members of our team have said that when the landlord goes to court, either on their own or through the use of a lawyer, that the argument would be, Your Honor, they did not suffer a financial hardship because they were getting all of these programs, they were getting unemployment, they were getting the additional $600 a week under the CARES Act through the end of July 2020. So in fact, they were not suffering at all. Therefore, we should get a judgment from the back rent, immediate warrant of eviction. Some members of our team believe that that will be the course of action and that the court will stand behind that. And we're hoping for that. We're hoping. We don't know if it will, but we're hoping that the court does. Now, the reason why we mentioned the Tenant Safe Harbor Act and how holdovers play a role in that is that under that Article 7 of the Real Property Procedures Law discusses evictions. So, any tenant, even in a holdover, under this Tenant Safe Harbor Act, can bring up a financial hardship. Now here, this point right here is the most scariest part of the entire Tenant Safe Harbor Act. One of two very scary parts. If the tenant can prove that they suffered a financial hardship during the COVID-19 covered period, which was from March 7th until the pandemic is over in your county. It is a county by county law. If it's over within your county and everything is back to normal prior to COVID-19, then this Tenant Safe Harbor Act dies in your county. Not in the state, but in your county. If the court deems that the tenant did suffer a financial hardship, the landlord will get a judgment for the back rent, but they will not get a warrant of eviction. They will not get a judgment of eviction. That means your tenant stays in the apartment and does not have to move. So you can file all these evictions now, but know in your mind that if there's an inclination that the tenant is suffering a financial hardship, the judge can very well rule in favor of the tenant. You'll get a judgment, but you will not get the eviction. The tenant will stay on the property. Now the COVID-19 covered period is from March 7th to whenever that could be. That is when malls reopen, gyms reopen, theaters reopen, when everything reopens. One of our colleagues / team members said the other day in our offices that it's over when you can go watch a basketball game in a local arena. It is over when you can see Billy Joel at the Times Union Center, Madison Square Garden, the Glens Falls Civic Center, Proctor's Theater. When all of those are open and you can go and participate in all of them, then this act should die. But as we know, as we've seen, Governor Cuomo is not sure whether or not he's going to open up schools in the fall. If he does not open up schools, then this COVID-19 covered period could very well go until at least January 2021. So even if you get the judgment, they will not be evicted if they have faced a financial hardship and the court says that they have. Even in a holdover case. Even in a holdover case. When you're talking about, well, money was not an issue. It is now an issue. So the big question, the two biggest questions, the two biggest issues that landlords are looking at right now is when will this COVID-19 covered period come to an end? And will the judge determine, through the broad use of the phrase financial hardship, will the judge determine that the tenant in fact suffered a financial hardship or did not suffer a financial hardship? So you wanting to file these evictions now is great, but you must realize, you must realize right now, there's the possibility that your case will be heard in front of a judge whenever that will be, but there will be no warrant of eviction issued. Just a judgment. That, if you take anything away from this video, take that away in your mind before you want to start a filing with the court, when you may know that the court may rule that the person has suffered a financial hardship. Hopefully the judges will see past that and realize all this money that they've been getting in, some of them have doubled their income with the CARES Act, that they clearly have not suffered a financial hardship. They just decided to say, I'm not paying you, because there's nothing you can do about it. You can't throw me out, I'm not paying you. Hopefully the tenants will come to their senses and realize that there's a possibility that this could happen right now. We're hoping, our fellow landlords, we are hoping that in fact the judges will see through that and rule in your favor that they did not suffer a financial hardship. We're hoping for that. But we want you to be prepared for the possibility that they will not do that. So what will happen is, right now, this is the law of the land, the law of New York State. As I alluded to earlier, landlords who are not in New York State or have rental property in New York, you may say this may not apply to you, and it may not right now, but it may apply to you tomorrow in your state. So take away some of the information that was provided to you here, all of it. Take it all and bring it back to your landlord association, to your attorneys, so that you can formulate a strategy to counter whatever your state may do to keep tenants on the property without being evicted. Because here in New York, that's the one thing that the government does not want. They do not want tenants homeless. They want them to stay where they are. So landlords already have a mountain as high as Mount Washington to try to overcome to get the tenants off the property. Landlords, thank you for watching. We want you to subscribe to our channel. Please subscribe. Leave your comments below. Do you think that this is fair? That yes, we can file evictions? Do you think it's wrong of these impediments that are put forward in front of you? Is it wrong that the possibility that your case could be only given in judgment but not a warrant of eviction? Leave your comments below. We will respond. Hit the like button. Hit the notification bell so that you will be made aware of future videos that will keep you up to date. Now, mind you, this video is done July 9th. The laws can change July 11th, July 12th. The Administrative Court Chief Judge Lawrence Marks can change some things. Cuomo can change some things. The state legislature can change some things. Things can be changed whenever. And when that happens, we will be here to present that information to you. Landlords, as we've said before, we're here with you. We're there for you. Watch that video regarding the CARES Act so you have more information on that. Landlords, be safe, be well, take care.